is the part where I also make a few brief announcements about stuff we're working on and have coming up before I turn it over to our speaker. So I don't have too much to announce this time. Our talk next month is going to feature speaker Byron Reese, who's going to be talking about the ethics of AI, and specifically, issues around things like algorithmic discrimination and just a lot of the thorny ethical and moral quandaries of increasingly turning our society over to be managed by machine learning and data algorithms. So if you want to get into the law and philosophy of implementing those systems, Byron's talk should be very interesting. And then November, we're going to have, I'm blanking on his last name, but Daniel, he's going to be doing a talk on a lot of the tech law around like a utility regulation. So for those of you who really want to get down into the nitty gritty of the wiring that powers our digital world, that could be a pretty interesting one to attend. We have a few other potential talks in the pipeline that will probably come up at some point, but those are still all being booked. We also usually have a holiday party that will probably be sometime in December. Details forthcoming depending upon what our usual sponsor is willing to provide this year. So stay tuned about that. Also just kind of a couple general initiatives that we're trying to take some early stabs at that you're always welcome to get in touch with us if you want to be involved. We're exploring, there's been a movement going on around quite a few cities in the country to try to put reasonable regulations on the public use of facial recognition technology. Most famously, San Francisco, with the help of Oakland Privacy, a member of the EFA, got facial recognition in public places banned, basically. It can still be used in private spaces, but not in public spaces. So we at EFF-Austin definitely want to explore the possibility of eventually bringing something like that to Austin. Of course, these sort of efforts always take time and bandwidth, of which mine and a lot of the boards is increasingly rare these days. And as I always say, we're a volunteer-run organization, so if there's an issue you're passionate about and you want EFF-Austin to do it, well then come talk with me. I'd love for you to be the one who does it. See anything else. There's a few other issues that we're exploring, but just in general, I'd say that if you want to get involved with this activism, we're always in need of volunteers, so definitely holler at us. I think, as I said, I didn't have too much in the way of media announcements this time, so that's, I think, what we're working on right now. Is there any announcement anybody in the room would like to make relevant to this community? Shameless self-promotion allowed. If you think there's something going on you would like to inform people about that is of interest, feel free to share. Okay. All right, in that case, I'm going to quit rambling and trying to see if I can think of things to say, and I'm going to turn things over to our speaker this month, Ritika Gopal, who is also a board member at EFF-Austin. This is actually an interesting meeting in that I think we technically have 9 board members, but I think this is the first time in a while we've actually hit 3 at the meetup. David here is also a board member. Yeah, well, we do what we can. We're all busy people. So Ritika is basically is trained as a technology lawyer. She's worked for a number of fairly prestigious groups, including she was on the team for South by Southwest, and she, in general, she's a graduate of UT Law, and she's passionate about, she's passionate around issues of the intersection of technology and law and society, particularly, like topics in the space of digital law, which you might be surprised to learn as as she and our other board member, Alex, also UT Law grad, will both say, you'd be surprised how little a lot of lawyers care about tech law, actually. They're often shockingly ill-informed on these issues and not even interested, actually. So we're very lucky to have a couple lawyers who are more future-facing on our board. But so I've been wanting for a while to pick Ritika's brain and get some of her expertise in front of our followers here. And a topic that presented itself both because Ritika knows quite a bit about it and because it's quite a bit in the news these days. If you follow digital civil liberties issues, it's one of the main things that the EFF is currently trying to push in their advocacy. And if any of you are the types who like to go meet with your elected representatives, especially during, like, say, the August recess, although that has just passed us. But in general, if you're the type who likes to personally meet with your lawmaker and advocate on issues, know that advocating on Section 230 of the CDA is an issue that EFF wants you to hammer with your lawmakers. They basically consider it the most important tech, digital civil liberties issue that is actively in the public sphere being legislated right now. Like, I think it's even higher than their attempts to restore net neutrality right now. I think they feel this urgency because, so for those of you who don't know, and Riddick will tell us a lot more, but Section 230 is a section of a law called the CDA, the Communications Decency Act, that was passed in the 1990s. It's a lot of people in the digital civil liberties space consider it. It is the law that everything you love about the internet is possible, and without it, you don't have the internet as it currently exists. And why is it so imperative that we increase understanding of why this law is important right now? Well, because you're seeing a bipartisan push to repeal this law. And as I always say, if you see both Democrats and Republicans trying to get rid of a law, it's either a really bad law or a really good law. And Riddick here is basically going to be arguing why it's actually a really good law, and that why the arguments on both the left and the right for getting rid of it are really, at the end of the day, they're politically self-serving and are ignoring the greater good that this law provides. So why don't you take it away, Riddick?
Hi everyone, thank you for that introduction. I'm going to go ahead and give you just a quick overview of CDA 230 immunity. So essentially, the CDA, Section 230, CDA as a whole, was passed as part of the Telecommunications Act of 1996. And when it was passed, the internet was, fairly new and unregulated. It was a new medium of mass communication. And the CDA represented an extensive overhaul of telecommunications law since, as it had existed since 1934. So one of the primary purposes that the CDA was passed was that Congress wanted to better protect children from the then recent surge of online pornography by means of allowing ISPs to self-regulate and censor content voluntarily. And so tucked within the CDA is Section 230, which basically protects websites from traditional publisher liability for illegal content that is posted by third-party users. And so specifically, if we're going to get to the text, it provides immunity for what you call interactive computer services, or interactive computer service providers that distribute and make information available to folks, but such information is created by third parties. And so basically the definitions sort of are very key within the Section 230. There's the interactive computer service provider, which is, I'm going to go ahead and start calling it ICS. That is afforded, so it's like blanket liability, versus what is a carve-out called information content providers, which I'll go ahead and start calling ICP. So you'll have to forgive me if I mix up the acronyms a bit. I mean, I'll try not to, but sometimes it can get a little confusing. And I'll get into that in a bit. But essentially, just have these two sort of categories in mind: ICS versus ICP, because largely the issue with applying CDA 230 is that it's given today's technological realities, it's difficult to categorize whether a given use case is a ICS or ICP. So this is basically the text of the Section 230. ICS is defined as information service, and I mean, I'm not going to read it out loud, but basically, if you look at the underlined words and the things that I give an emphasis on, you can see that it's a pretty broad definition. You can probably think of many websites and online services that kind of fall into this, this type of function. And further along within that definition is what's defined as an access software provider, and that is it's very broad as far as what a website can, or an online service provider can do with respect to third-party content, but is sort of falling short of the level of control over content that it would take to become an information content provider. And this will all make sense in a bit, but basically for now, just like understand that it's a pretty broad definition, and it boils down to an ICS is a online technology that allows it's basically passive internet operators who publish information provided by others. So the distinguishing factor is control. There's basically no like added there's curation, but there's not sort of that like editing that a magazine would do in publishing articles. It's like the Reddits of the world where third parties post content and there's very little control. Okay.
I'm curious, is there a threshold of content moderation above which you go from being an ICS to a traditional publisher? Like, what is, is there a defined legal cutoff, or is that part of this debate?
That's the problem. That's the problem, and I'll get into it. It's the thing is that because technology, online technologies have become increasingly interactive, and a lot of platforms increasingly engage with their users. It's kind of interesting to see like where do you draw the line as far as is the platform involved enough in terms of publishing the content that they should be within the realm of what you would classify as an information content provider, or are they just merely presenting the information and maybe arranging it a bit, but not editorializing it to the level that it changes the meaning of the message. But it's a really fuzzy line, and that's basically that's the linchpin of the problem. It's courts just don't know what to do, and technology makes it more difficult. But essentially, you can kind of liken, an ICS to say like newsstands, bookstores, libraries, where they're just kind of a vessel for information. And the idea is that it would be nearly impossible for these distributors to check the content of every third party before publishing it. So it's just a way to make sure that we don't stifle innovation online. So that's why this this immunity was made. Now, in contrast to that, information content provider is again, it's defined in very overlapping terms, because what does it mean? What does it mean to create or develop in whole or in part information? Like, I think if you develop information in part, like that, you could easily be an ICS. That's you could argue that as an ICS you're developing information in part. So it is very fuzzy. But essentially, when this was drafted, the original role of an ISP was to just give access to the internet, but now we're seeing that ISPs kind of are getting into the content creation game, and like also ICPs, they're increasingly taking on a more ISP role, and I'll get into that. But it's just it's very confusing. But essentially, an ICP, you can analogize that to, like I said, newspapers, magazines, where you get like lots of submissions, and they get to handpick which ones kind of go with the theme of that week's like zine or whatever. But essentially, the idea is that an ICP has the knowledge, opportunity, and ability to exercise editorial control, in contrast to an ICS, which is just kind of like funneling it through. And so, because of that control that an ICP has, it warrants holding them responsible to some degree to a traditional publisher liability, which, if I can give like a little quick backdrop on defamation law, it's just a publisher can be held liable for illegal content that it publishes. So there's a standard of care that you have to exercise when you publish like content on, say, the New Yorker or something. So one of the issues, again, is that in the 2 decades since CDA has been enacted, we've seen rapid growth of internet technology and communication. So there's more newer, sophisticated internet technologies and interactivity between platforms and users, as I mentioned. And so basically there's just been a blurring of distributor and content provider functions. And even in the text, you can see it's unclear where, you know, an ICS provider's actions, you know, those that provide and enable access to the content begin, and where an ICP, which, you know, does not enjoy immunity, where an ICP's action begin, where, you know, an action might constitute a partial creation or development of content. So it's all really fun legalese. And I kind of like touched on this a bit. You know, technological advances are exacerbating the issue. I mean, for example, you've got courts conferring ICS status to online service providers, say like eBay, for example. E-commerce is kind of big in this arena. There's a level of control as far as, you know, advertising various products and like categorizing them, you know, providing labels and things like that to guide your user. Now, whether that constitutes as like exerting publisher level control is, you know, that's kind of a question that courts grapple with. So, I mean, I can think of one example. There was a case with eBay where eBay was sued over the sale of third-party bootleg items, and the court ruled that, you know, even though they were exerting some sort of, they were providing the means to buy such items, they still enjoyed ICS or Section 230 immunity because, again, they were just providing that third-party content and not going in and editorializing it. Let's see, 1 second. Another piece which is interesting is that a lot of traditionally like analog publishers, I guess, like news publishers, have sort of started going into the online space. So you find this interesting dilemma where if you publish something on the New York Times, like in print, that, you know, that falls within the content provider bucket of things. But then if they're online and you know, they're publishing comments, like in the way that they might in a magazine, it's just the liability question can kind of be different just by virtue of it being online. So
letters to the editor is not treated the same as the comments section.
Exactly.
Legally.
Exactly. So that's interesting because conceptually, you know, they're pretty similar. So, and I was reading about a North Carolina newspaper, I think in 2006 or something, the pilot announced that it would begin to offer free wireless access to the internet. So it's interesting because it's like a newspaper that is sort of taking on an ISP role. So does that make it fall within the ICS category because they're providing access to the internet? Like, you know, obviously it remains to be seen. But it's just interesting. I think the larger point is that all these like ICSs are sort of taking on ICP level of controls. ICPs are kind of like taking on traditional ICS roles, and so there's just this mismatch of stuff and sharing of roles between the two. So I think it's important to kind of look into the congressional intent and legislative history that drove passage of the CDA. While the text itself does not, you know, kind of explicitly say these are the things that, like these kind of technologies fall within, like how to delineate between an ICS and ICP. I think, and this was one of my, this is kind of part of my recommendation in general, is to look at the original congressional intent to drive how courts applied the statute. But essentially, you know, because like lawmaking does not occur in a vacuum, so if you take into account the political, you know, legal policy landscape and kind of look at the congressional record, for example, and see the comments that were driving the passage of certain, you know, certain pieces of CDA and, you know, compromises that were made, you can kind of get an idea of like, okay, this was the intention. It's the courts, you know, courts are tasked with implementing that. But of course, because there's kind of like a lack of clarity as far as bright line rules go in categorizing between ICS and ICPs, it's led to like a lot of, it's, you know, blotchy basically as far as judicial application goes. So essentially the act was passed as a response to inconsistencies of common law. So basically there was a case in which, it's called CompuServe, it's a popular one, but basically a federal district court held that CompuServe was liable as a distributor, was not held liable as a distributor as opposed to being a publisher because it had virtually no editorial control over the information posted by users on its site. So it was a classic, like, illegal third-party content was posted, someone sued, and, you know, it's a classic case of, it was just a distributor. This was before a CDA was enacted, so it wasn't classified as an ICS or anything. This was just, okay, they they are going to be liable as distributors, which is much less than publisher liability. So that's like the traditional framework of liability pre-passage of the CDA. But then Prodigy came along, Stratton Oakmont versus Prodigy Services, and that kind of like really spurred legislative action. So in that case, in New York, the Supreme Court held that the defendant website was liable as a publisher for libelous content posted by a user on one of its bulletin boards. And Prodigy tried to rely on CompuServe, but the court held otherwise, saying that because Prodigy had an automatic software screening program installed and a business policy that permitted its board leaders to remove certain messages, they were exercising the requisite degree of control that was sufficient to deem it a publisher. And so basically, legislators found this to be very problematic. They were alarmed by the possibility that websites could be held liable for removing harmful content, such as child pornography. And so they basically, it spurred the talks about drafting this legislation so that a website's good faith removal of harmful content would not heighten it to a standard liability that publishers face. So, and I kind of in my research definitely combed through the congressional record, and at first, some representatives, I think Representative Exxon, he initially proposed legislation that would be, far sweeping, and websites would be like liable to the publisher level, whereas other representatives plus the industry itself and the Internet Association, they disagreed. There's this back and forth, and it's really interesting to kind of read the accounts that took place. And so you can kind of tell, though, just from these selected quotes from the congressional record, that there was definitely a reluctance to hold platforms liable, because at that time the internet was this new frontier, and there's because of the potential for development, it basically drove the drafting of the immunity. And so essentially, after a lot of back and forth, the final text ended up including a list of policy objectives. And so you can, if you go, if you look up CDA 230, you'll see that these are the objectives that are supposed to drive what, whether or how a entity is classified, and whether it should enjoy the CDA 230 immunity. But some of these, some of the phrases that pop out to me are, promoting the continued development of the internet, preserving a vibrant and competitive free market, developing technologies to maximize user control, and I think number 4 especially is one that I saw as a consistent theme, is just basically enabling websites to be able to create technologies and filters that remove illegal and harmful content, but not at the expense of, you know, the immunity that they enjoy as just free vessels of information. So that was a persistent theme, and I think, at least as far as Congress goes in coming up with the final version of this act, it seems like allowing self-regulation, you know, is not considered mutually exclusive to protecting, you know, harmed individuals and enabling them to have effective recourse for, you know, people that are harmed by content that's posted online. So essentially, I mean, it boils down to basically balancing two competing interests. One is, you know, the interest in encouraging self-regulation and innovation among online service providers, you know, on the one end, and then the interest in protecting harmed individuals' access to means of effective recourse. So, you know, I think it's interesting if you recall that one of the underlying reasons of why CDA was passed was because out of this desire to better protect children from pornographic material. But it's interesting that in drafting the CDA, specifically distinguishing between ICS, which is defined quite broadly, and then you know, kind of creating a carve out for those entities that kind of cross over control-wise into the ICP arena. They made this interesting policy decision or trade-off to use sort of this like wide-ranging, expansive safe harbor as a vehicle to fulfill what was otherwise a pretty small goal. So you know, it seems that offering, I think their policy calculus was that, you know, it's just better to offer wide-ranging protection for innovation and self-regulation while enabling victims access to effective means of recourse where circumstances warrant treating an ISP as a traditional publisher. But I think because ICS is so broadly defined that it kind of, I think if you read between the lines, you can see that there was a lot of prioritizing of you know, development of internet technologies. So the overall problem, though, is that, I mean, so far we've kind of discussed how ICP and ICSs are defined in overlapping terms. You combine that with, you know, increasingly interactive platforms, just an ecosystem of online technologies that makes it really hard to distinguish what's what, and blurring, you know, the blurring of distributor and publisher functions, you know, then of course leads to, you know, what's a sort of judicial misinterpretation. So without bright line rules to guide statutory interpretation, you know, courts across the U.S. have increasingly begun to sort of take a Rorschach-like approach to the question of whether, yeah.
Bright line rules, sorry, I don't know what that term means.
Oh, okay, so basically, I mean, bright line rules would just be like, if you just look at a law and it's very clear, like, from the text, how to apply it, that's basically it. So like if you like board games, for example, you look at the rules and it's like quite clear what steps you have to take to follow the rules. This is more because of the way it's been drafted. It hasn't sort of stood the test of time because of the ambiguities that have been like baked in.
You can think of a lot of edge cases that the law doesn't explicitly tell you what to do in those edge cases.
Yeah.
More or less.
So, yeah, that has basically led to sort of an inconsistent approach among courts all over the U.S. And so, what then happens is that, you know, when courts are inconsistent in applying the statute, that creates an uncertainty as to, you know, how courts will rule on immunity, and that scares the private sector because they want to know exactly, you know, what if they create technology, they want to know like where along, what's the risk profile of that technology. So what ends up happening is that platforms will tend to overcorrect and censor. So there's not an incentive to, you know, sort of allow all this third-party content to come in if there's a chance that, you know, in the way that they distribute the information, that, you know, they'll be held liable because some court thinks that they're exerting this level, the requisite level of control over the content. And so it might, you know, lots of, you know, technology activists say, you know, deride the way that it's been applied because, you know, it's going to lead to tech companies, you know, being reluctant to develop and innovate. So there are a few, I selected some cases which kind of illustrate just how, I mean, for the most part, CDA 230 has been applied pretty generously. CDA, the Section 230 immunity has been applied pretty generously. But there are some sort of, you could say, glitches that, you know, for example, roommates, and I'll talk about it, that, you know, a future litigation could rely on roommates instead of something like Carafano. But I'll kind of go into each of these cases, and they're really interesting. But basically, there's little, yeah, sorry. Okay, so one of the cases, so basically, this will kind of highlight what, like, I went into, I studied like 20, 30 cases, looking into what the entity did, what tools they were using, and seeing how the court reasoned whether it was an ICS or an ICP. So, for example, in, you know, Gentry versus eBay, there were category listings allowing users to classify products, color-coded star symbols, and power seller ratings, linked to customer feedback, and this was all done for the purpose of boosting, you know, user confidence in sellers. In that case, even with that level of control, eBay was classified as an ICS, interactive computer service, and was not held responsible for unlawful content that was produced by third-party misuses of the tool. In Batzel, basically, this was a website about an email newsletter about museum security and stolen art, and essentially the director of security would periodically put together an electronic document containing like emails sent to him, comments by himself as a moderator of an online discussion, excerpts from news articles, just a bunch of things that he sort of handpicked. So in this case, he kind of exercised you know, editorial discretion, but then the remaining listserv was just kind of like an amalgamation of posts that the users had sent to him automatically. And the ruling was that, you know, the defendant was an interactive computer service because, again, it kind of fell into the development of information, you know, which was more substantial than just editing. Oh, sorry. The Batzel was found liable because the editing was more substantial than just editing portions of an email. I'm gonna have to look back into that actually. I think I switched that around. But anyway, I think the two major cases though I would kind of focus on just highlighting the inconsistencies are Carafano and roommates. So Carafano, so Metro Splash was or I don't know if it still is, but it's a dating site. Essentially, once you logged on, you went in and answered a host of multiple choice questions, and specifically 50 questions for menus providing 4 to 19 options. And these details kind of matter because they'll kind of go into the nitty gritty as to like, did the user have control in terms of like fashioning response, and was it like free form answers versus just picking like an answer that's like, 3 answers out of 4 choices, or sorry, 1 answer out of like 3 choices. But essentially, the court ruled that Matchmaker was an ICS and did not develop or create the content on the profile, even though it required members to fill out a questionnaire. So there is this element of, if users are required to fill out a questionnaire, then does that exert a level of control? That in this case it didn't, but later on in Roommates, the court found that it did. So essentially in that case, it's almost the same. Roommates.com was a housing website, but they were sued because they were violating the Fair Housing Act. And so in that case, before subscribers, could search for listings or posts, they had to create profiles. So it's kind of the same as, it's similar to Metro Splash, where you had to create a profile and like add content. So it's, sort of inducing content from the user.
So if I understand, sort of the key point in the issue around both these cases was the fact that the content the website served you depended on the answers you gave. Did this count as the website, be public their questions?
Yes, exactly. So it's like, based on the questionnaires, there is a level of control because that drives the user experience. And so in Metro Splash, I think it's because it was in the dating context, questionnaires are kind of like necessary for that service, I suppose, for better matching outcomes. Whereas, if you apply that to Roommates and suddenly the questions are a little more dicey, where it's like, very violative of the Fair Housing Act, where you can bring racial preference into it, I guess. That was the court found that that website was within the ICP classification. So it's interesting because a lot of the facts are very similar. It's just the context is a little different. But essentially, in Roommates, the court introduced this material contribution standard, and the reasoning was that Roommates had developed questions and choices, and then published profiles based on users' answers, and then also, developed a portion of the information displayed on users' profiles. So essentially, the solicitation of preferences through unlawful questions was seen as development, and that's kind of the development of information. That's that key phrase from the ICP definition. But it's interesting because you've got these 2 cases, and it's hard to distinguish between the 2. So the California court added this material contribution standard just to kind of like make a little carve out for otherwise a pretty strong tradition in applying the immunity. And then another interesting case I found was Blumenthal, and this is interesting because AOL was seen as was ruled to be an ICP, even though they basically had a user agreement, an agreement with Matt Drudge, a user of AOL, who would basically publish reports on AOL at no cost, and they entered into a license.
Matt Drudge eventually founded the Drudge Report.
Yeah, exactly. And in exchange, AOL paid him $3,000 a month, but otherwise, basically it was weird because AOL is in contract, in primitive contract with Matt Drudge, but so and presumably they're looking at the content and they're bringing it through. So maybe there's a level of control, especially if you consider entering into a contract, developing information. But the court did not rule in that case that it was an ICP and subject to publisher liability. So, there's so many more cases that are just it's weird to see. You could apply the same reasoning in another context, and it could just go the other way.
Like
there any
these.
instances where like algorithmic editing has like pushed them into like an ICP kind of category where like automated filters are doing the editing, like, and selecting all the content?
I don't, I think in that case, I mean, so the cases I've seen, and I mean, there might be data, I don't know if there's like something that's happened this year, with that, but the applying filters is, and editing in that way, where it's not, you know, you're not changing the meaning of the content, falls within, would I think normally fall within the access service, access service provider, which is a subcategory of the interactive computer service.
Okay.
So it's basically, you can still remain an ICS if you filter content but don't substantially change or collate the content you do let through. Like the issue with the fair housing one is that they were arguing that they weren't just filtering based on the answers, they were constructing / publishing new data based on the provided answers.
But that's the thing, you can argue that the same thing was happening in MetroSplash.
Yeah, and I haven't read either case, so I'll ask you. I mean, I would assume that the lawyers Ninth Circuit, and there's a few years apart, so I'm assuming that the lawyers argued about, or based some arguments on Carafano over MetroSplash. It sounds like, because it's Ninth Circuit, they do this. They were pretty sure they needed to find a way to get the violation of the Fair Housing Act in there.
Yeah.
And they were constructing it, so the question really is, in the cases you've seen, does it seem like the rule really might be, if your results are doing something that is otherwise gonna be a problem, you're violating copyright, you're doing something else, we're gonna find that you have something to do with the content. Because we need to enforce that rule, and we don't have any other way to get you. But if it's benign results, no harm, no foul, go ahead. I mean, does that sound like where the cases might really be falling?
It kind of did, and especially, you know, with EFF-Austin, that was kind of spurred by Backpage, which was this website that was facilitating, you know, sex trafficking of children, and I think, well, I guess in that case, they were successfully able to argue that,
Well, I mean, Backpage did get shut down.
it got shut down, but
You had bad social outcome.
right.
Even if, you know, we're a libertarian society, they'll just say, well, that's the rule, we're gonna go with it.
Yeah.
Well, yeah,
You know,
I mean, you
They
want to go.
hit the yellow line.
Well, you want to go into that one if we're talking about sort of the, you know, is there harm based on how you parse it? That one's especially difficult if you're going to apply that standard, because it's like you leave the site up, you're arguably facilitating child sex trafficking. You take it down, you're making consensual sex work far more dangerous for people in that industry.
I mean, just not to put a conclusion out there, but I noticed that when you started to make a comment about how, in the 96 Act, they were sort of reacting to common law and setting a couple of guideposts. And it seems like what's then happening is common law is continuing to get created, and the common law may actually be, if it's bad, we need to find a way to make it not happen. But if it's not bad, fine.
Yeah.
Go
I
ahead.
mean, I do think that's an interesting point, especially because, yeah, it really, the roommates one really does just kind of read where they're like, well, they were discriminating based on race, but we can't technically prove it, but we also can't let that stand either. So we have this ambiguous statute we can use.
Yeah.
Right, and Ninth Circuit's always really good at coming up with ways to do that.
Right, because it really sounds like, yeah, a common theme it seems is that you can literally take two almost identical cases and change just one detail, and suddenly you flip how the court rules of if it's allowed or not.
Yeah, and it's interesting because, so I mean, to be clear, I wouldn't endorse the behaviors and the technologies that, or whatever roommates.com was doing, but I think further down the line, that just because that case can be used as a tool for, you know, kind of getting other more benign websites into into legal trouble. It's just there is a problem in terms of you want to apply it consistently, but yeah. So I think there is an issue. That's where that policy balance comes in. It's like, okay, well, if you're violating the federal the Fair Housing Act, or if you're facilitating child prostitution, like maybe the prioritizing the harmed victims recourse, kind of
Right, it just
goes-
seems dangerous that if, you're basically exploiting ambiguity in an unrelated law to prosecute people for crimes, you basically have created a backdoor to circumvent due process and start creating all sorts of abuse.
And I mean, you see, that's like that happens all the time, right?
Right.
So that's kind of the chief concern with the inconsistent application of this statute. So we touched on this a bit, but there have been some recent legislative developments, and please, feel free to jump in here if there is anything that you've heard of, because I know there's a very hot topic, but this was pretty big a while back. EFF-Austin passed in response to Backpage, and I think in reading about it, a lot of people are, kind of concerned about the way it's drafted. What does it mean to knowingly assist or support sex trafficking? The way it's drafted is pretty broad. So again, as we were talking about it, you can kind of use these textual ambiguities to get a lot, basically chill otherwise constitutionally protected speech. So kind of a wide swath there. There's and it's rife with problems from what I hear.
I mean, if you don't mind a quick
Yeah.
sidebar, just because, so basically, EFF-Austin is another issue that Electronic Frontier Foundation's followed fairly closely. Their head of advocacy, Elliot Harmon, this was an issue he personally did a lot of work on. This is an interesting issue partially because EFF, has never been afraid to take bold against the grain legislative stances, but the thing that's interesting to note about EFF-Austin is that it passed with overwhelming bipartisan support. I believe it was 99-1 in the Senate, with only Senator Ron Wyden, who often on tech issues is the lone voice of sanity, voting against this. And it's easy to see why, because it's incredibly easy to get tarred as you are for child sex trafficking if you vote against this bill. But and one thing Elliot Herman, though, has pointed out repeatedly about the problems with EFF-Austin is none of the lawmakers involved in this conversation were listening to the actual parties supposedly harmed by the behavior. Elliot has toured the country and spoken extensively with people who actually, they're sex workers, and that's how they make their living. And that community universally hates this law and thinks it is the worst thing ever and has made it incredibly dangerous and difficult to do their jobs. And that basically it's returning to the old days of them having to consort with pimps and put their personal safety at risk. So it's definitely been an issue EFF's been following, and it's a good example of that. Yeah, that even things that seem to have a real bipartisan consensus, there's often a lot of complexity on these digital issues lurking under the surface, especially because our lawmakers often are not very educated. I'm not surprised that Wyden was the only one who saw greater nuance here, because he actually tends to be quite informed on these issues. So yeah, just wanted to, because Elliot, when I was in San Fran a few months ago, was telling me a lot about his work on this. So I just wanted to share that sidebar there.
Yeah, absolutely. And then another, piece that I found interesting is that this summer there's, I think, Representative Hawley introduced the Ending Support for Internet Censorship Act. It's being, I think, turned around in the committees right now, so it hasn't been passed or anything. But it's interesting because basically this kind of touches on the political climate, right, where you see all these platforms. There's been increasing evidence about that platforms are kind of censoring based in alignment with its own political views. So Facebook, Twitter come to mind. But basically, and this is also you've seen Nancy Pelosi and Ted Cruz, it's bipartisan, as far as, lawmakers are threatening companies like Facebook and Twitter, with modifications of the law like this.
I think it's important to point out that the reasons that Nancy Pelosi and Ted Cruz are mad at an entity like Facebook or Twitter are very different reasons, even if they both want to get rid of Section 230.
Yeah, I mean, right, because, but both are, basically the lawmakers are threatening these platforms that, with this kind of modification, if platforms don't behave in a more quote-unquote responsible or neutral way. And so, essentially curating and censoring various political opinions in what, as far as what they're saying is, is exercising that requisite level of control. Now, on the other hand, the Internet Association said, well, hold up, this is a kind of pretty bad act because it's CDA 230 is a law that allows online companies to moderate and remove content already, content that no reasonable person would want online. It's already illegal content. So that content could include sort of destructive political viewpoints if it kind of incites violence or something like that. So it's interesting because this act would task the Federal Trade Commission with certifying that tech companies are approaching moderation in a neutral way. So that's also giving the FTC a lot of power and judgment there. But this would only apply to companies with over 30 million active users, or in the U.S., 300 million Facebook, YouTube, and Twitter, and other major platforms. But I think this is just a way for lawmakers to kind of curb the influence of these big platforms on political discussion. But that's basically, that's kind of like the general sense of what I get as far as recent developments are going. I think there are a couple key lawsuits that are in the pipeline that I, frankly need to read more about. But I think I'm hoping that, application of the law will be more consistent, but that remains to be seen. But I think the way that I kind of approach delineating between ICS and ICPs is first figuring out, where to put that fulcrum and placing that fulcrum based on congressional intent and policy objectives that are enshrined in Section 230 and basically why it was drafted in the first place. And so I would say, basically I kind of, in my research, there were a few things that I figured people or courts should pay attention to. First is that, if you're given just an example online service provider, that you should first look at whether, the degree of resemblance that it's a relationship to the content, how closely does that resemble traditional editorial functions? So do the ISP's actions or tools objectively mirror an ICP's traditional editorial functions? So that includes decisions to publish, withdraw, postpone, alter. That's one thing you could look at. Another thing you could look at is, if it strays away from traditional editorial functions and is closer to what is defined as the Access software provider functions. So, is it just a vessel for information? Is it just filter, screen, transmit, receive information? Based on those two, you can kind of figure out okay, it seems to be more, closer to an ICS versus an ICP. The third thing I would look at is looking at the source and nature of the content at issue. Is the, and this is looking at the third party that's providing the content. So is the content essential, provided willingly by a third party, or is it basically is it required to, does the third party kind of fill out a form or questionnaire to use the online service, or is it, sort of voluntary? That's something that you could look at to figure out the degree of control that an online service is exerting. There's also, I think this is where it kind of, this is the meat of what I would look at. Just looking at the level of involvement and alteration with respect to the content at issue. So you could look at, so basically in my mind there's 4 levels to this. You know, was the act, is the online service just acting as a passive conduit, which, you know, the information is just unaltered. That's one end of the spectrum. And then you kind of go a little bit further. Does the online service add peripheral content? So, you know, titles, rating systems, symbols in the way that eBay does sometimes, or you know, you've got these e-commerce websites that kind of arrange the information but don't actually like dive in and change it. And then you have to ask, you know, a couple sub questions. Does the peripheral content change or add meaning to the original content's message? To what extent do they leave the, you know, central content intact? And what is the underlying purpose of the peripheral content? So those are things that I would look at, you know, if you're looking at a online platform that's kind of arranging the information. And then there's the next, you know, step you look at is the level of control materially that an online service exercises. Is it materially modifying third-party content? And that's kind of the language I pulled from roommates. Basically, it is content so materially modified that the underlying message has changed, and it's not what the, you know, the user was trying to communicate, or there's some sort of enough deviation where it's different question.
Oh yeah,
Yeah.
just that. I just wanted to let you finish your thought. That I just had a tie in there.
Oh, okay. Yeah, I mean, that's one thing I would look at. And then the last level is, of course, creating original material, which would definitely bring it within the information content provider bucket. But yeah, go ahead.
So, so that I think that ties into an interesting scenario that I'd be curious what your thoughts on it would be. So, obviously, a lot of traditional content publishers, though, as we've already discussed, whether HuffPo as an ICS or an ICP is already an ambiguous question. But to take a less ambiguous, more traditional one, like say the New York Times Online, already content publishers have been annoyed at, say, a service like Facebook because they feel you're stealing ad revenue, you're stealing clicks from us because everybody's just seeing the stories on here, etc. Mm-hmm. Although Facebook has argued back that they're just serving the content, they're not a publisher. You know, and I have very few good things to say about Facebook, but I do actually find myself somewhat sympathetic to that argument.
Sure.
But then here's where I wonder where it gets fuzzy. One thing Facebook has started doing in an effort to tamp down on the criticism that they, via their hands-off moderation, allow the proliferation of fake news, they've started flagging certain news stories people share as this might be fake news. Have they actually inadvertently suddenly turned themselves into a publisher and increased their liability by doing that?
I mean, I would say so, maybe, because that's quite a, like, I've seen that, some of the...
I've seen it occasionally, yeah.
Right, they're laying on their interpretation of the information, which
Mm-hmm.
might affect, you know, an end user's intake of that information.
I just find it weirdly ironic that in an effort to remove criticism and decrease liability, they might have actually increased their liability in the way the law is written.
I have to wonder, like, because I can't imagine that.
Well, they have really good lawyers, so
yeah,
I'm
like,
shocked.
They
they've
do,
got to-
and some of them are. But,
Some of them.
But in these cases, and I really haven't read up on them, are they distinguishing, are they saying company is either bucket A or bucket B? Or what I suspect to be the case, they'll say, well, with respect to this, they're
Yeah.
bucket A. So maybe in that particular case, it's, and I'm gonna bet, knowing some of the people in DC work for Facebook.
Wait,
As
I'm not a
outside
lawyer.
counsel.
I'm not a lawyer. I'm
Um,
just being a
but-
smart aleck there.
But thinking
Like,
of the
wait a
people
minute.
who, what they might say, I could see them saying, all right, well, with respect to that article that you're labeling as fake news, you're just a conduit. But if you get it wrong, and they sue you for saying they're fake news and they're real, Facebook, you're on the hook.
so once again, almost sort of a, well, if you were right, it was fake, no harm, no foul, but if you
Or
were
then,
wrong.
you're supposed, either way, a court's expensive, so if
Right.
they wanna haul you in, and if Facebook says the National Enquirer is fake news, and the National Enquirer says, yeah, but we're rich, so we're gonna see anyway. They might have a case.
Yeah, I mean, for simplicity's sake, when I was going through all the cases, I mean, yeah, typically, you know, a court will kind of go through all the actions that, you know, that are, that a online service provider did with respect to the content. So there, you know, in, I believe it was in Roommates, or one of the major cases in which, like, the question, like, one piece of it was exerting publisher level controls, but then the you know, another piece just you know, soliciting just free form answers was, you know, within ICS within the ICS territory. So it's piecemeal for sure.
Right.
But I mean, still they're liable for whatever pieces of, or whatever aspects of control fall under the publishing liability,
Right.
publisher liability.
And I guess, you know, one other question I'd like to make sure we get into the discussion here and get your thoughts on would be, so a lot of this is already a side effect of, as anybody who's attended my intro to net neutrality law talk knows, a lot of these issues we're seeing here are basically created by these fundamental ambiguities of which parts of the internet infrastructure are regulated under Title II or Title I of the Telecommunications Act, basically whether they are information service providers or telecommunication providers, basically. And so a lot of the conflict we sort of see with like something like Facebook is that we see this inherent conflict of like invariably the retort when say somebody gets deplatformed from something like Twitter or Facebook, occasionally a far left commentator, but usually a far right commentator gets deplatformed. The retort will be that, well, it's fine to deplatform them because basically this is just a Title I service. It's, you know, and just they have no right to an account on that site, and they have no right to the algorithmic promotion of content that site provides to the network. So, you know, they can go start their own server, you know, nobody's kicked them off the internet, etc. But then, of course, the retort from people like Mr. Yiannopoulos was recently whining, even recently in the news, that, you know, he now has a group on Telegram where he has about 15,000 people he directly messages, but he's whining that he used to be able to reach millions easily, and so this is apparently still censorship. But, you know, as much as I do not like that man, I just still think that there are some very interesting issues being raised here of like, where does the line between a raw platform and content begin and end, and when is it censorship and when is it not? Because it was much more cut and dry back in the days of just the telephone. It was like, the telephone's the conduit, they're not liable, everybody can say anything they want over the telephone, but the telephone also didn't have things like algorithmically boosting for cash the content some people injected into the telephone system.
Yeah.
So I'd just be curious your sort of overall thoughts with the research you've done on these issues of like, how do we get this right where we don't engage in censorship, but we also don't let money artificially promote vile views to people on the right or the left?
Yeah, I mean, that's a tough question. I wonder. I mean, and like to further complicate what you're saying is, you know, you've got websites like Reddit where you've got third-party mods who, and so the mods will talk to, you know, I mean, they're in cahoots with the company, but the mods exercise control over the content, but then they're all, and like they get to set the subreddit policies. But as far as I think, I mean, the solution I think is to have a standard that you can like very neutrally apply so that it's not driven by the context, and it can sort of, but it's like, hopefully it's a standard that can capture, you know, the diverse ways in which like online service providers interact with their users. Go ahead.
I don't want to interrupt you, but I want to, when you're done.
I mean, I don't know, I'm not sure what the solution is, honestly. I obviously support broad immunity, because I think the potential, fallback from trying to expand publisher liability and bring tech companies into that fold, I think it will chill free speech. And one little carve out that I kind of was playing around with, but I'm still not sure whether it passes muster, is that maybe you could kind of create a gross negligence carve out to the ICS immunity. So if you have if an ISP's like facilities and tools are structured in such a way that there's a non-minimal widespread violation of the law that's like patently predictable. I mean, I tried to come up with like very limiting terms.
Like under your gross negligence thing, would like Facebook not screening their ad buys for political ads for foreign currencies fall under gross negligence?
I'm not sure.
One of our former board members was pretty high up at Facebook, so I've definitely had some of these conversations with him about that topic.
I mean, maybe gross negligence means if a terrorist group is using.
You need harm. If it's negligence, then somebody has to be harmed because it can't be speculative.
Well, also, I mean, by that standard, like Al Qaeda's on Twitter now. Yeah. Sure, they try to boot their accounts, but they are on Twitter.
Yeah,
and then of course you have Jack Dorsey's wonderful quote when asked, like, why do you let white supremacists be on Twitter? Where he's like, I don't like white supremacists, but if I kick them off by actually applying our policies, I have to kick off certain Republican lawmakers, and that will get me in a lot of trouble, and they'll accuse me of censorship.
But here's so one of the things we've noticed in law is we tend to silo. We start looking at a tort, and we start thinking, well, tort, and we forget, but there's all this other stuff out there. All the internet has to exist on facilities, ultimately telecommunications facilities, because it's going over the wires or either over the wireless or wires at some point, or fiber. To put that stuff out there, you have to get permits, you have to get your, in Texas, the SPCOA, but you have to get, you need a certificate of public interest. And that's a place where, let's say Facebook got really into doing filtering. Well, then they want to go, and let's say they wanted to get into building their facilities, because that's really where you have a bottleneck. Because remember, MySpace was really big for a while.
Right.
It's probably before you were born, but it existed, and it died, and something happened.
I had to count briefly.
But it died because the facilities were still there, so somebody could come in and pump it off and all that. But if Facebook were to start bumping out Verizon and AT&T and building its own facilities, now it's really got a monopoly. That process where you get access to the street to build that facility is a great place, I think. That someone can say, hey, wait a minute, these people don't serve the public interest. They're very biased. It's a completely different area of law, but at least then you can say, well, you don't have to worry about judgment on negligence. It's, don't let them dig up the street. They're not allowing everybody to play on their system.
I mean, that is an interesting point. I can certainly say that you run into so many stakeholders once you start digging up the street that it's very, unless somebody is universally beloved, you can stop them pretty quickly.
They usually just get bogged down in paperwork.
Well, right, exactly.
The municipalities just don't
can't.
They don't even process the paperwork.
Even Google can't dig up the street in any efficient manner.
Exactly, and that's the thing. Is so the minute like somebody were to come in and try to do that, especially, and Google's a great example for that. You know, if it's some company you never thought twice about, I won't name any clients, then they kind of go through. You know, it's just some facility. Fiber company XYZ kind of gets their way, nobody bothers them. Google wants to tear up a street, suddenly people pay attention, suddenly they're having problems. So there might be an opportunity there.
That'd be interesting.
Yeah, definitely.
Yeah.
Something else that was tangential to this I wanted to potentially raise.
I mean, Google's interesting in general, just because, I mean, there was a case that I came across, and I'm fuzzy on it, but essentially they were being sued for, I mean, the argument was that their use of AdWords, and like classifying, prioritizing information, brought it within the publisher liability, but of course, it was found to be an ICS, so. But Google is interesting because, people only look at the first page, or the second page, so it's like curating the information.
Is that algorithm curation or not?
That's
Right.
really interesting.
Yeah.
And
Yeah.
how is that algorithm getting weighted?
Well, yeah, I certainly think, and as more and more stuff is being governed by code and algorithm, the settling where that line is when we're dealing with code is going to become more essential in these discussions. But I guess one thing that I really want people to try to take away, and I'll be interested in hearing your take, is how, when we have people are very tribal and they listen to their tribal leaders when it comes to political debates. If a conservative sees Ted Cruz saying the solution to our people being deplatformed is get rid of Section 230, they listen to him. And when liberals see Nancy Pelosi saying the way to stop hate speech and harassment online is to get rid of Section 230, they listen to her.
Yeah.
What do you think the way we can convince both these sides? Fine, you may have a legitimate grievance about a problem here. Your rights may actually be being abused here. But how do you persuade both sides? Okay, fine, there's a problem and we need to find a solution. But getting rid of Section 230 not only is not going to actually solve either of your problems, if anything, it's just going to make it worse.
Yeah, that's the issue. It's like, how do you convey the fact that if you get rid of this, it's not gonna solve the problem you're getting at, because it's again, let me think on this.
Because we literally, not even in the editorial section of the New York Times, so the front of the business section, there was literally an article just a couple months ago that was basically I was very upset the New York Times let such biased reporting through, but it basically completely frames the Section 230 as a story, and it's how does hate speech proliferate online? Because this law protects them. And it's really? I come to you for news. This is an editorial masquerading.
That's
But
just
it's
a
true.
journalism
So
problem.
here's just a posit, throw something out there, because I think you covered it initially. It's the common law approach. Nobody's ever going to be smart enough to write the golden. There's one golden rule, and even that's subject to interpretation. He who has the gold makes the rules. But the common law approach, maybe that is the way to deal with the thing that's pissing Nancy Pelosi off. Somebody should take somebody to court, see what the court says, and the thing that's pissing off Ted Cruz, see what the court says, and I'm gonna bet the court's gonna come down and say, you both don't get to control the media.
Fair enough, but then what do we do if they both are let's now pass a law, so the court has to see it.
That's the
our
thing,
way.
if they stop, maybe this is the thing where the lobbying should be, don't pass a law. Keep taking situationally specific, fact-based items. It worked for 1,000 years, or since Justinian? We could go back to it for this. It works in torts, and every time there's a car accident, they don't say, pass a law. They say, oh, you suck, you did the wrong thing, you drove over the yellow line, pay me money and we'll leave the yellow line where
Well,
it is.
it's interesting when people apply different standards to different things based upon the way it's emotionally loaded, because you're absolutely right that we have car accidents all the time, people don't freak out about it, they try to pass standards to make cars safer, they do tort, where it's
They make
appropriate
it
to get
light.
damages, etc.
Right.
But yet here with this issue, everybody's somebody did something bad online, let's throw out the entire internet. It's
Right.
no, that's not what you do.
Exactly, it's somebody went over the yellow line, paint all new yellow lines. That's
Well,
not
the
what
issue
it's
is
about.
that it's hard to, because you've got politicians that are on the podium and they can just speak with a lot of emotions, it's, they can sway their people
I
in
know,
the right
I
direction.
guess that's
Whereas
my
if you have
point.
the common law argument, it's no one really cares about the sort of the mechanics of how the law works, and it's hard to make that sexy,
Well, it's just also interesting what a politician can emotionally rile people up about. If I got up on the podium as a politician and started being cars are a menace, they'd all brand me a loon and nobody'd care,
Yeah,
That's true.
no, totally. You drive down, on Cesar Chavez, there's a sign there, it's says, how many people got killed at Texas roads this year? And it's
are you trying to run up the score? What are you saying with this thing? But you can do that, you can, and, you know, sometimes, especially these very fact-specific things, you know, my bet is, I don't think anybody's really that smart. I don't think Einstein would have said, oh, I can come up with a good law. I think Einstein was smart enough to say, let's look at each situation.
It's relative.
Right, and I think if you have like a.
That was awesome, that was so good.
He's been waiting all night
Yeah.
for that one.
Oh my God, I'm a dad who could use that joke.
I mean, yeah, the closest I got to it was like, if you just have a set of factors that are malleable enough, it can take on, hopefully, the majority of, set of facts, and hopefully, if you create a mechanism in which those factors are applied, then you get decent, or outcomes that are consistent. But of course, that's easier said than done, so I'm still kind of.
Is there like one change you would make to the ICS or ICP definitions that you think would remove some of the ambiguity in these cases about who is what?
I would definitely redefine ICP, because the way it's drafted now is, there's so much overlap with what an ICS does, especially the bit where it's, actions that constitute publisher, or publisher-like actions are partial development or creation of information. Like that partial development part really bothers me, because I think
you would actually want to go in and say, okay, what does partial development actually mean?
Yeah.
Let's
or just
narrowly
strike it
and
out and make it more like
strike it out or narrowly or
Yeah.
rigorously define it, but don't just have this term that I can literally drive a truck through
Yeah.
of what it means.
I would also say
That's
that
a good
the definition should be maybe a little more updated as far as like kind of at least furnishing some more details, like, okay, peripheral content of this type, if it does like X, Y, Z to the information, then maybe, it's considered ICP type functioning or ICS type functioning. So, but of course, you don't want to leave that to the legislators either. So it's kind of this weird thing where it's like, you just want someone smart enough to like draft it, but it also work.
It really
So, yeah, it's an interesting problem.
Well, it's funny that I do meet, smart people who are politically adjacent, but it seems whenever they run for office, they don't get elected, so it's discouraging.
They don't bring up people's emotions enough.
I don't know, 17 years in DC, and I never met one who was smart enough.
Well, I mean, what did you ever meet Mr. Wyden? What do you think of him?
Him, no. But a lot of staffers that were looking to get really nice fishing lodger.
Yeah, I was just curious about him because, I'm not joking. Invariably, whenever I see Congress doing something stupid, there'll be some sentence in the article. The lone voice of dissent was Mr. Wyden, and I'm like, oh, thank God. Anybody in the crowd have any questions for our speaker here? Anything that we haven't covered yet?
I was a little curious about the legislative history. It said that Section 230 specifically was part of this thing that got passed almost unanimously in the House before it became Section 230 of CDA. And then, 7 years later, 47 state attorneys generals are like, actually, we don't like this. Can you take it out? Why was that so fast? Is that right?
7 years later,
Yeah, 2013, I think.
I imagine.
Like, was nobody paying attention?
Well.
I imagine. The state AGs probably. I don't know. Actually, I'm not sure. I'm not sure why they would. What did they? Do you recall the reason?
They just they wrote to Congress asking for criminal and civil liability to be immunities to be waived.
The state AGs wanted the criminal. Well,
And
wait.
so this.
so they could go after people then.
Yeah,
I think that-
So
I think there's your
40,
answer.
47 out of 50 AGs wanted the immunity section stripped and asked for it.
7 years after it was passed.
Well, I mean, to his point, I'm not surprised the AGs wanted it stripped.
Yeah.
Who was paying them?
Yeah,
Well,
I'm
it makes-
guessing
well,
that
it
the
makes
AGs
their-
weren't- well, they probably weren't the same AGs 7 years
Well, it
before.
makes their
Okay.
job harder. They got to find
Yeah.
something else to stick them with.
Well,
I just think it was so popular, and then it was, now it's like.
Well, maybe it's popular
the reason sex
legislation.
trafficking is happening.
Well, also don't forget, the world was different when this, the 96 Act, when this went through and all that. Nobody
Right.
thought the internet was a big deal. AGs weren't thinking anything about it.
Right, but it happened because of this moral crisis about kids and pornography, like what's different, it's still.
I mean, it
a
might
moral
just be
crisis.
that in the way that it was applied since it was passed, I mean, it has been applied pretty generously, so the immunity has kind of like touched a lot of a variety of online services, and so maybe they're kind of, I mean, and I'm totally postulating, I have no idea, but maybe.
I'm completely
not comfortable with
guessing
that.
here, but given the time frame you're talking about, maybe what happened was that one thing that the CDA got used for a lot, that the people, so like, the thing that essentially was that law is nobody knew how important Section 230 would be when it was passed. It was almost like this little throwaway section in the much larger bill, and it took a number of years before people realized, oh wait, this thing is a powerful law.
Except for Wyden, who had to cite.
Except for Wyden, but basically, one thing that it started getting used for a lot, which I could potentially see having pissed off certain very powerful people who then put pressure on AGs to do something about it, is it's one of the main reasons that in the early 2000s copyright infringement was able to proliferate on the internet, because the sites that had all these couldn't be held liable for their users posting all of it. So I'm totally guessing, but that might have had something to do with the reason.
That makes, I
Makes sense.
don't remember exactly, but I'll bet that's what Google would say if we Googled it right now.
I mean, but you know, but Section 230 is why, as much as they wanted to shut people like the Pirate Bay down, they could never do it because of Section 230.
Yeah,
And also,
like,
don't
you
forget
know,
how much money is behind protecting 230, because there's at least one giant ISP I know of who really cares a lot about that immunity.
yeah, and I think, you know, you're probably right, because notice and takedown framework, like, is not very effective, so.
Yeah, no,
Yeah.
it's not, by virtue of even, well, I remember the early days of YouTube, you could find any infringing copyright you wanted on there, but even now, if you just search for the right keywords, they can't totally police it. There's a whole bunch of stuff on there they don't want on there.
Yeah.
Yeah, and yeah, I mean, there's a process, and you wanna get it taken down. Somebody gets hurt, and somebody's supposed to go do it and all that, and I would say it's just an honor system, but
Well, and of
it
course,
kinda starts out like an
Well,
honor
yeah,
system,
and
like, oh, I'll send it this,
of course, the whole takedown system, that could be a whole nother talk about how that thing then can get abused to actually censor people with the threats of takedowns, actually. So, the people game every system. I know, I'm a programmer.
And for every program, there's a hack.
Well, I mean, my friend Chris Brown, who was a sci-fi author, but also a tech lawyer who's spoken here, yeah, he and I both agree, yeah, like programming and law are very similar activities, actually.
I used to code COBOL.
Oh, good.
Anyways, do we have any final questions for us?
I think it's getting off.
It's just great. I enjoyed it.
It's really,
Yeah, well, thanks for coming out. We hope we'll see you again next month. AI ethics should be a good one. Yeah. Do we have any final questions before we let our speaker go?
Well, thank you for coming out, I appreciate it.
And thank you for everybody for listening. I think there was I always like the talks where we get more nerdy about law or tech, and this one definitely, delivered. It's like, ooh, subdivisions, yay.
this is like group therapy.
Yeah, I was a little worried, like, how much into the weeds to go into, because I could have definitely,
No, I appreciated that you were actually citing the relevant things. It lets people who want to learn more actually know where to go. For any of you who are free, we usually go over to Firehouse for drinks if any of you want to go and chat for a little bit. So that's up to anybody here. But thank you all for coming, and we'll see you next month. You gotta head out?
Yeah.
Okay.
Oh, you too. Thank you, Bob. You're up for this.
It's like a geek out.
I had a good quick, that was it. Yes, I will
I'm
look
using
up
your jokes.
stuff, and I will shoot it over to you, and I'll see what happens.
All right, yeah, great. I definitely stay in the loop. Did
oh yeah, and
you
let's,
guys-
sorry, I got caught up with this presentation, but, next week if you're free, we should, so we were emailing back
Yeah,
and forth.
right. No, I definitely think as far as you both are interested in doing some of the content generation stuff for the website. So yeah, definitely,
Yeah.
you should get together and talk about that. And I owe both of you continuing to edit our website and continue to get it in a better state so that it can actually properly present your blog content. So the quicker you get on that, the more
Sure.
you force me to quit procrastinating and actually get that done.
Okay, cool.
And you guys want to go grab a drink real quick and chat for a little bit, or do you guys all gotta get somewhere?
I could use a drink.
I would love to, but I actually really have.
All right, guys. Are you free, Vincent? Or you gotta get going?
If you
Yeah.
both are going, then I'll, yeah.
Sweet.
All right.
Then,
Well,
I don't wanna be the one that makes it not happen.
Anytime
But I'll have to be
I'm
quick
free.
about
Oh
it.
yeah, well,
So
I would
next,
yeah.
want to,
or
yeah.
this weekend,
Yeah.
if you wanna? Okay, we'll email.
And also, I'll be in touch, guys, both about figuring out our board meeting, because I think, as David was saying, it's technically supposed to be this Sunday, but it's the third Sunday is weirdly early this month, so I may see about if we can find another date, because I also just need to see if Chris can host us, or maybe even, I might, depending on how free the board is, I might try to get it where, yeah, we have a board meeting, but, maybe we also can just hang out as a board, because social camaraderie is good too, so yeah. I'll be looking into that. All right, well, good to see you, David. Yeah, we'll be in touch.
And your name?
Oh, I'm Ritika.
Ritika.
Yeah.
Nice to meet
What's
you.
your
Vin.
Vin, nice to meet you.
Yeah. Riddick is another one of our board members here. So, Vin, you were on the